The second requirement for the formation of a contract, in addition to an agreement between the parties, is consideration. Consideration is one of the key concepts of contract law. It is an essential element needed to make a contract legally binding. It is also unique in that it doesn't exist in this form in civil law jurisdictions. So what is consideration? Consideration is provided if something of legal value is bargained for and exchanged between the parties. That is, each side to a contract needs to provide consideration. Consideration can consist of various things. The most common consideration is money. That's what happens, for instance, when you purchase an item in a store and use cash or a credit card to pay for it. It can also be an object, so instead of paying in cash for a purchase, you can give a valuable item to the other party. Next, consideration can consist of a service that a party provides. For example, instead of paying for an item using cash, you provide legal consultancy services in exchange for the item. Finally, consideration can take the form of a promise. This can be either a promise to do something that one does not have a legal obligation to do, or promising not to do something that one has a legal right to do. A promise to do something that one is already obligated to do does not satisfy the legal value requirement of consideration. For instance, an agreement to modify an existing contract is not enforceable since both parties are under a pre-existing obligation to perform the contract. Of course, this does not mean that a contract cannot be modified. An existing contract can be modified on the condition that new consideration is given by both parties. That is, both parties must give or promise something in addition to what they were giving or promising under their pre-existing contractual obligation. Taking a contract for the construction of a house as an example, the contract could be modified when the builder promises to build an additional floor and the customer promises to pay an additional sum of money in return. The legal value must further be bargained for and exchanged between the parties. A gift does not satisfy this requirement. A promise to give someone a gift is not consideration because the recipient of the gift is not doing anything in return. Even a promise to give someone something in exchange for something that the other party has already done for you in the past does not meet this requirement. This would be considered to be past consideration, which is not valid consideration because the bargained for exchange element is missing. For instance, if a party today promises to give you money because 4 months ago you provided a service for them, this would not be a valid contract as the necessary consideration is missing. Your end of the deal, the service offered in the past, has not been bargained for and exchanged as part of a current contract. As long as some sort of legal value is exchanged between the parties, the courts will not step in and evaluate its adequacy or make sure that it is fair. That means that the parties to a contract can still make good bargains and bad bargains. That's the principle of freedom of contract. An exception to this principle is that if the consideration is grossly unfair, a court could decide to step in and adjust or invalidate the contract. We will discuss this later under the heading of unconscionability. However, this rarely happens.